sympathy with Tom. I partly share Tom's view about ethical positivism, but so far as the issue of a well-framed decision where there seems to have been a real interpretive choice goes, I think that the process is one of steadily narrowing discretion. I think that the judges in the early European Common Market cases clearly gave the treaty a concrete sense of what they were capable of doing. They didn't go beyond the framework of the treaty. In that sense, they didn't invent. On the other hand, among the available choices, they chose one rather than another. So the determination that they gave to the treaties involved an act of choice, which was a partly lawmaking choice. Once you take that step, then a series of other decisions follow that wouldn't have arisen under the other one, and at each time the range for choice narrows. This is a characteristic process of the progressive concretization of case law. Now, the kind of law making that goes on through that interpretive argumentative process is different from the kind that goes on in a legislature or among the high contracting parties agreeing a treaty. The whole process of law involves all of them. Now, you could try for a system which radically screwed the lid down on the judges doing much of that at all. And Tom's in favour of that. And I want the pressure cooker just a little more slackly fastened. Charles.
I've always been fascinated by the insights of positivism, and I think tremendous insights about the nature, the aspirations, and the possibilities of law. And I've always tended to think that the problems with positivism in the past have been that they've tried to see these the only insights. They've tried to build a system and theory of law, and theories of legal system based just on those important insights about rules. And of course, the discussion here is mulled in two senses. Firstly, that there are a lot more insights about rules that are being brought out, and also in a far more open way, so that it's not just the only insight. And the other thing, of course, is that because positivism talks about rules and reasons and has many insights about that, so this has a natural attraction to lawyers. But one of the problems I've had with Neil's institutional theory of law, and also especially with Hart's view of rules of recognition and so forth, is that when you point to, I suppose, the limitations of rules just in ordinary communities, what Neil talks about in Hughes and what Hart used to talk about in supposedly less developed or primitive law, that some of the answers, of course, are always in terms of rules. And so that if Hart sort of points to various problems of just having a system of primary rules, and the answers were in terms of rules, and the answers, the kind of institutionalisation that Neil's talking about, is in terms of new forms of rules. So you've got a problem with the rule with trying to work out rules of cues. And the answer is to have somebody who will provide new rules or clearer rules or expositions of rules or final decision, which is in Kelton's term makes a new norm for that individual. But I think one of the interesting when you look at real societies and real institutions, that institutions aren't just rules. And in fact, very often the thing is that the answers to the problems of rules that you describe where you've just got systems of primary rules is not necessarily just to have another rule of a higher order. To actually create an institution which will actually make decisions, even if you don't actually give rules and reasons. In one sense, of course, the answer to these kind of problems is just to have somebody to decide. And something I said on the first day, and something I said in Disorder of Law, and I'll still stick to it now, is that if you have somebody who can make the decision, you don't necessarily have the rule. It's not necessarily a question you have a person to make a decision for a new rule. If you're uncertain about what the rule should be, you just give somebody the power and they make the decision. And something I often said is the judge is actually functus when he's made a decision. If he actually gives the rules, of course, is there good reasons for giving reasons. But in fact, the thing is an important part of the is why, of course, my own analysis always did start with power. It's not about powers against rules. It's been looking at rules within the kind of messy interactions, the real social interactions we have, which is not just in terms of rules, but in terms of people's powers and perceptions and understandings. And that the answers in terms of the institutions we create shouldn't, I think, just be seen in terms of rules, but should real flesh and blood institutions, which to some extent deal with the problems of rules not by creating more rules, but by actually exercising powers and making decisions. And so, whereas I think that it's very good to emphasise the importance of institutions, I think there could be a weakness if it's just seeing those new rules. An institutionalisation is just about creating new rules rather than creating institutions in the fuller sociological sense, bodies with powers, resources. And I tie this into something else. I mean, Summers used to talk about different techniques of law. That law isn't just about making rules. Legal institutions make decisions. They sort of knock people's heads together so that they go away and they no longer have a dispute. They actually have resources and they hand out money. Things like in say pursuing human rights, we have a range of institutions which actually pursue human rights, and a lot of it's related to the rules that are in the Human Rights Act, but that a lot of it's actually about doing other things, handing out resources, educating people, and so forth. And so I think that whereas, again, things no one should lose sight of the insights of positivism, the importance of rules of law, it's important that one doesn't think that this is all of law, and that especially the institutions of law shouldn't be just seen in law-based terms.
You guys, we'll go back to this. Jennifer.
I'd like to ask a slightly different version of Walter's question, because I'm interested in the nexus between judicial activism and democracy. So instead of asking, should judges uphold moral understandings of the community even if he or she feels that they are wrong, I'd like to ask the question, is it acceptable from a democratic perspective for a judge to knowingly disregard the moral community views on moral values if he or she thinks they're wrong, if he or she disagrees with them? And I think there's at least three different questions. I'm sure there's a lot more, but at least three different questions that we might ask in trying to get a sense of the nexus again between judicial activism and democracy. One is the basic question: is judicial activism consistent with democratic principles? Now, I'm not sure we've given as much attention as we should to the fact that not everybody's going to come to the same starting premises. Some people are going to adhere to a rules-based view of democracy. Others will have a more rights-based view of democracy. The political science class will think of it more in terms of a process view of democracy as opposed to perhaps more of a substantive view of democracy. But if you have a right or a substantive view of democracy, you might have a view that the ideal of democracy is to ensure that citizens have an equitable influence on political decisions that affect them in both their personal capacity and in their public capacity of contributing to the general character of the colony or the effective or legitimate use of the state's coercive power. If that's the case, then we wouldn't be as troubled by courts intervening, even under common law, even without a Bill of Rights, intervening to infusing more of a substantive equality notion into interpretation. A second perspective is, a second question you might ask is, what is the relationship between the kind of conversation we talked about yesterday and decision making? And a lot of this, again, came up yesterday, and I don't want to repeat a lot of it, but it's not just a matter, perhaps, of having more voices in the conversation. The question is, are voices always heard? I talked a little bit about yesterday how women often feel excluded from the process, even when they are part of the process. The tenor of consultation is
that some combination of primary and secondary rules can be found in societies that aren't externally legal. So I'll leave that as a record. Leading into my question, I'm very proud that Neil has firmly distinguished positivism as statism from positivism as, in the philosophical sense, as distinguishable as law. If one pursues that, I think one could even come to the view, taking the idea of positive law within the statism framework as the old idea of use for the evil and hang around it at its head, one could come to the view these two senses of positivism may be incompatible. Which doesn't mean you can't have a positivist in the philosophical sense theory of the state. Many sociologists have tried. So I'll come to that, if I may, by starting, and I'll be quick, with the idea of the queue. The queue with a queue manager, in the examples that we given, seems to have nothing to do with the idea of custom. It is an administrative arrangement which follows from the relations established by the law of property. If it has any relation to custom, it will be historical. There will be a reinstitutionalization of the customary law into legal law. But if you're going to try to do that, then as Paul Hannon on the anthropologist I'm referring to came across a lot, you have to be able to show there was this custom. And he was unable to do it. If one then is unable to show this distinct body of custom, then the concept dissolves into the general body of morality. What morality? Where? What are these social relations? In particular, to what extent are those things we're looking at as morality already conditioned in their concept by existing legal relations? I refer particularly to the individualization of morality that occurred at the same time as the Justinian Digest was being received, the causes for that being the individualization of the economy starting in Northern Italy. At that depth, what we think of as morality is already legal. And in so many other ways, like the individual with the ordinary economic system. Is there then an external relation between law and morality? Or is it an internal relation within what you may have called the universe of rules, which might nonetheless be seen as having a legal dimension in every place where it is, in this law that leads from before the cradle till after the grave?
Can I maybe intervene for a moment? Right. As far as Charles's point is concerned, I agree that we shouldn't be unduly hung up on rules. And one thing that I was trying to do was say let's be clearer about the line between informal social norms and rules. Since Wittgenstein and Hart and so on, people have tended to call both of these things rules, but they seem to me to be so interestingly different that you better have that it would be wiser to try and discipline ourselves to a slightly different mode of speech, which is why I draw the line I try to draw between norms, social norms, and articulated rules, or in the case of the official decision maker, the implicit rule of the decision. I think there's a useful, phenomenologically interesting line there that we should at least observe when we're thinking about life, and trying to be articulate about this sort of issue. Now, so I agree with you, an awful lot of life goes on far better without anybody formalizing and writing it down and so on. Although I think Tom would rightly say this presupposes relative equality and relative consensus. People get on quite well. I mean, a group like this, where we're all sort of people of a certain kind of employment status, and all made contributions to it. We all respect. We know we respect each other. That's a good setting in which you don't need to write all that, because people will, on the whole, not take advantage of each other, and to the extent that they're tempted to, a wee bit of social pressure will be applied and all that kind of thing. This will work, but there's lots of settings where it won't work. Where it seems not to work. And anyway, even if that's not true, there are a lot of settings which are not structured that way, which are institutionalized in the sense that I want to say. And one of the interesting questions for the theory of law is, well, what's it like when it goes that way? And can we think of rationalizations, rationales for its being that way when it is that way? Now, as you say, sometimes what you want is not rules but decisions. But the problem then, and this relates to Ian's point, is the problem of the authority of the decider. For somebody to be the decider whose decision goes, either they have to have the biggest gun in the room, or they have to be regarded as the person whom we ought to take it from on this matter. And if they're the person whom we ought to take it from on this matter, either this is because there is an articulate, enacted, or managerially created rule which says obey the queue manager, or we have, by that kind of collective exercise of practical reason that we call custom, come to agree that what Tom says goes, or whatever. And for this, and actually that's what we do agree for the purpose of this seminar. We're very egalitarian, but Tom's the guy who's got to make the difficult decision. We want to get on with it, and we accept them. We do that. That's how it is. Now, I'm not saying that this goes back to, I'm not a great believer in immemorial custom. I do believe in immemorial custom, but I know that we don't know anything about it because it's immemorial. Custom is all around us. All I'm saying is that, it's the thing about, I once heard Frank Mackelman, the old myth about the world is held up by an elephant, and the elephant stands on a turtle. And somebody says, what about that? What after that? And the guy says, it's turtles all the way down. Well, it can't be turtles all the way down. All articulate normative orders depend upon some current customary normative order. I mean, you might say, but Australia's got a written constitution. Sure, but that does not mean by fatal necessity that the Australians will obey their written constitution. But over a number of years, many years, a practice has evolved of referring our disputes to that text and those people who decide it, and the guys with the guns on the whole obey those people that decide it, and all this kind of stuff. So what Kelston, I think, wanted to treat just as the fundamental hypothesis of legal science, which from the point of view of legal science is all that it is, in real life is necessarily a customary norm or set of norms observed among the members of a community. And that's really, when we get back to the discussion about is a rule of recognition always and necessarily customary? Well, yes, the ultimate one has to be, because it couldn't be anything else, I think. That's why I say 1 plus n. Now, of course, the appointment of the taxi marshal at the airport doesn't rest on custom, but go back far in, pursue that up the particular pyramid of authority, and you eventually come to, well, that's just how it is. Turtles all the way up. Right. Now, Janet's question, which was along a somewhat different line, and first of all, the issue about community standards, I should have said earlier that the point is, again, the Walden point, I think the Walden-McCormick point was both made in different settings. The problem about these issues is that there isn't a single community standard. We're puzzled because there's not a community standard. There are sets of rival judgments, positions and interests. And of course you are correct, aren't you, that it's just a kind of truism, but important truism, that the most heard voices are the voices of the most powerful, because they're powerful because they get heard, and they're heard because they get power. It's just like that. So that is the argument for entrusting some of this to agencies who do not face early elections. Just the point you make, we can't sell this to the electorate of Wagga Wagga, well, fortunately, the Supreme Court judges don't have to answer tomorrow or next year to the electorate of Wagga Wagga. But so from the point of view of one aspect of democracy, we've de-democratized it. We've unhooked the decision from the say of the people. And what we want to know is how far you can do that, and yet nevertheless latch it into the sense of a community in which the people's say in the end goes. And you have then to go around and look. Well, the people's say can only go for legislative institutions that make laws, but the laws will come out needing interpreted, and then how will the interpreters interpret them? And that, I think, does come down to then the point. We ought to address this in the spirit of a theory grounded in a theory of general practical reasonableness applied to legal things, which Alexia and myself and various other people have tried to do, not very successfully, have a shot at it, keep going at that job. Now, in that in that sense, the judges and other people ought to have in mind that in Wagga Wagga they don't like queers, and would put it exactly that way. But we are not here to decide in that register of language at all. We're going to say there are different sexual orientations, and how do we, in a free society, let them live together and get on with things? So exactly not framing it in the demotic and exactly going at it in the light of, I think I very largely agree with a lot of what's in Walker, in the light of as it were, those standards of fair mutual relationships which come out of the whole constitutional framework, which can be difficult to apply in areas of controversy, but we just have to do our best. I think, as Jeremy said, judges are more often too deferential. Well, we just have to go along with that, rather than too courageous. In most of the cases where we look back and wish the judges had done a better job of it when they had the chance. So, what I don't want to see, there's this real big contrast between Duncan Kennedy's critique of adjudication and Tom Campbell's ethics of legal positivism. Duncan really wants judges to have political programs and tell us what they are and be right out there with them. And there's where Fred and I think, are in the same camp. We acknowledge that there has to be this. We acknowledge that people will tend over time to hold one rather than another side in certain important issues. But we do not want our judges to be people who have political programs. That's impermissible activism. We want them to be people who decide cases that have to be decided in as reasonable a way as they can get around to deciding them at the time. American federalism makes this very difficult. Partly because, as Fred said, you've got this stacking up of things, and it just gets to the point. It's a bit like the problem in Europe too. It just gets to the point that one of the districts, the appeal districts, has developed a doctrine, and another one has developed a different doctrine, both of which might be perfectly reasonable, facially not unreasonable interpretations of the same legislation. But it's one country, and we've got to have one of these, not two of them. And so you've got to have somebody who can decide for everybody in that way. And if let them do it as reasonably as they can, and perhaps try to design your institutions so that they can be second-guessed reasonably easily. Don't make the constitutional amendment process too difficult. Let the people come back in rather than slowly. Right. Is democracy all that important in that sense? And somebody else, what does positivism say about this? What I was trying to get at, that silly remark of being post-positivist, is, and Ian made it too, didn't make the made the point. Positivism, there are no essences of schools of thought, are there? There's no such. I find it bizarre. Let us think of n theses, which everybody who holds is an exist, and everybody who denies any one of them is a non-exist. I think this is kind of crazy because on the whole, the history of ideas doesn't work that way. People aren't like that. I certainly am, anyway. There are some things, there are some insights which I find inventive, I think tremendously revealing, and we want to hold on to, and so forth and so on, and hard. But you wouldn't be doing this game if you spent the rest of your life in heroic exegesis of Herbert Hart and nothing else. Come on. I'm an autonomous philosopher as well. There are interesting questions that arise around focal points. I think there's an interesting question whether you are conceptually committed to some moral elements in positive law. I think there are very interesting conceptual questions about what morality is. If morality is radically dependent on autonomy, then that is the sort of key, that's the thing that cuts into it. Because the whole point of an organised society is that we are all partly autonomous in them. So there we go. I don't see that there is one sort of thing which is positivism or not. There is a program which is called the Legal Theory of Ethical Positivism, and we know there's a program because the guy that wrote it is just around the table here. You can sign up to that or sign up against it, or you can say yes but, and I'm saying yes but.
Okay, the next cluster, Wojciech, Nicola, and Arthur.
I would like to take up to go back to the point made by Walter and then developed by Leslie and Janet about the issue of conventional morality and how it affects legislation or judicial
is largely a matter of institutional design. That is that, importantly, it boils down to certain choice of values which should be made explicit and which inform the choice of one of a number of possible institutional designs of the legal system. Now, when I studied my legal theory in Poland many years ago, it was an accepted part of the academic orthodoxy that there is a strict line between norm or rule making and rule application, and that the legislators are in the business of rule making and the judges are in the business of rule application. And it was not so much a political orthodoxy, although probably to some extent it was also politically motivated, but it was sort of one of those conventional wisdoms of legal theory, which was as much entrenched in our academic tradition as it was in German, that's West German or French, etc. And I suppose most of us who participated in the practice of legal academia and who dealt with this considered it as a sort of fiction. I suppose in a way which in different words have been described by Fred. That is that, okay, we know that it doesn't correspond to reality because we know that the courts, especially appellate courts, often make rules in the process of concretization. But for some reasons it is good to believe, as if, to behave as if they didn't. And in Fred's terms, probably one good reason, well, there might have been invidious reasons given for this approach to separation of powers, but one good reason would be that by doing it, we will confine judicial lawmaking to a certain minimum. Now, obviously, this sort of choice was informed by a certain explicit or implicit, as more often was the case, value calculus. That is the idea that the cost of, in terms of loss of candor, of transparency, etc., of having a fiction, some sort of strategic approach to the truth here, are more than compensated by the benefits. And therefore now the question is, what are the benefits of such a particular strategic choice, that is, of behaving as if we believed in the strict line between norm making and norm application? And that brings me back to the institutional design. And my take on this choice of institutional design is along Walter's line. That is, let's ask ourselves the question, well, considering that community values or community standards or conventional morality or whatever will have to enter into lawmaking. Well, they have to. That's obvious as a major sort of democratic principle. If we have certain discretion about designing our institutions, would we prefer them to enter mainly at this stage or in the process of lawmaking at the legislative process, or rather in the rule articulation and the judicial process? Or where would we like to channel them mainly? Okay? And the answer to this has to be informed by our actual knowledge about those specific judges there are, their tenure, their responsibility, their accountability, their qualifications, etc. They link to the community as they are in a given system, and those particular parliaments which we have, or parliaments in the federal system, which we have, and how they are formed, how they are accountable, and so on and so on. And I suppose that if now we look at the debate or dispute between your approach, which is much more lenient towards judicial lawmaking, and on the other hand, Tom's approach, which would put much more focus on legislative lawmaking and would rather minimize the role of judges. The question is, well, do we have good reasons, good value reasons, to want to channel this taking into account of community standards at the legislative process or at the judicial process? And I would say yes, we have a number of very good reasons related to the reasons which underlie our understanding of representative democracy. Well, we would like community standards to affect lawmaking at the legislative process rather than in judicial decision-making process. Somehow, the way we understand representative democracy is that it is not sort of at the mercy of every changed sort of community standard or community view. That is, that there are certain processes which belong to community preferences, and which make them much more clear to the sort of Dworkinian image of what community morality really is in a critical sense, rather than the way he interprets Devlin's community morality in a more sort of positive sense, of actually replicating any moral views which are sort of in some sort of public opinion poll view of morality. Because we want our law to be a product of a reason process, to go through certain filters. We don't want any sort of emotion, any sentiment currently dominant in society being translated into law immediately. Now, this is, of course, there are a number of counter-arguments which may be put in, but I think this is the sort of value articulation which should inform a decision about institutional design, which in turn will inform a decision about whether we prefer Tom's legal theory of ethical positivism with its, well, sort of statist, I think, in a positive sense, statist and centralist emphasis, or your theory, which is much more favorable towards judicial lawmaking.
But not over the moon, right?
Neil, I really enjoyed your presentation. I think, like Tom, I think it's very helpful because it really clarifies what the different sort of ways we could go are here. I've got a couple of things. First, very quickly, I'm going to indulge in an aside about one of your asides, and that's the question about the autonomy of law, because I suspect I may be one of the people who've irritated you on this. But I think, I want to say, I think, and actually Ian made a very similar point to me over coffee the other day. I think some of what I was saying yesterday should better have been carved as the autonomy of legal science and legal method. However, I think that, for example, from the point of view of systems theory, there is a perfectly obvious sense in which law is autonomous. And if I'm wrong about that, then I haven't understood you. So that's sort of by the by. What I'm really interested in is sovereignty and post-sovereignty, but post-positivism is such a nice label, I'm afraid we should never have had that slip of the tongue. I'm going to run with that for a moment, because I think my question is how consistent post-positivist or an institutionalist are you? And it really goes back to the point that Martin was raising yesterday about the balance in our method in theory between conceptualism and empiricism, and I think it's another aspect of the difference between yourself and Tom. You mentioned, again, something of an aside, the fact that you've been working with people from different jurisdictions and so on. And I'd just like to hear a little bit more about both what you think that really adds to your legal theory. How far in that sort of comparative cross-jurisdictional work you've looked at pluralism, not just at the supranational level, I mean, in the obvious sense of the EU or whatever, but things like Lex Mercatoria and so on. And to the extent that you have, I suppose, if not, why not? And to the extent that you have, do you find the same convergence, jumping to a later part of your paper, between the linguistic, systemic, teleological, deontological sort of framework, which seems to be sort of one of the analytic parts of this
Uh, I have no idea how consistent I am. I suspect not very. The autopoiesis thing, yeah. I think myself that, for a reason that came out a moment ago, that it's a bit overdone. I remember once saying to Luhmann, this is really very bit like Kelsen, law regulates its own creation. Why is it that what judges make is law? Well, what judges make is law because when it turns up and people cite precedent to them, they enforce it and say that's the law. And how do we know that that's the law? Well, because we go to the judge. I think that a lot of the reasoning of this kind of thing is circular and self-referential in that sort of way. There's no way out of that. In that sense, thing is true. On the other hand, if it's the case that these things lock into, these things become actual, because and to the extent that there is a custom of observing them, then it's not all and only. The law does not make itself. The people, in effect, make it would be the wrong word, but the people make it law in their response to it. So that to that extent, there's always a way out of the windowless monads. In fact, the windowless monads have got windows. And that's, I think, true of the other systems as well. So I think system theory is full of very exciting might be too strong, challenging insights, but I sort of hold the line there. And also I want to say, again with Tom, hang on, the real sense of the law is and ought to be in the possession of politics. That's what a democratic country would be like. It would have a legal system, it would have lawyers and judges and so on, but in the end of the day, the political process would decide what they do, not they. And I'm as firmly signed up to that as Tom wants me to be. Right. Different jurisdictions. I think the different jurisdictions thing showed Wojciech's point. Yes, that it is a fiction. And actually, King James was told by Justice Cook, Chief Justice Cook, that he wasn't learned in the artificial reason and judgment of the law, which His Majesty's judges were, and really please buzz off. So how artificial is the reason and judgment of the law? Have we common lawyers got something that we do that is esoteric and known only to us, and perhaps the civilians something else that's esoteric and known only to us? I think the answer is well, no, not really. No, we actually do much the same kind of thing. We're more or less open about different bits of it. We have different institutional ways of adapting to it, and all this kind of thing. Now, what I want to say all along is no legislation applied in society without interpretation. It is not possible. That's the nature of the beast. General rules, how do general rules get out there into people driving cars or being fined for being drunk and all that kind of stuff? Well, because people read the thing and say, this is what it means. And in difficult cases say, but could it mean that? You can't get out of that process. You can only have more or less of it. I think that we therefore have to acknowledge and be open that there's only a choice between more or less, and say the key thing is that it be well done, that it be reasonably correctable, and that the correction should be through a democratic process. And that's the worry about constitutional adjudication, just the way that Tom poses it in the last 5 chapters of the book. I think I want to stress that the conditions of its being well done, and that we can't afford to sign off on that in the hope that it will effectively stop, because it will never stop. And none of us thinks it will. We only think that we more or less of it. And the institutional theory as an institutional theory has nothing to say about that, because at that level of theorizing, we're saying any legal system will be an institutional normative order, which will have institutions of this kind in it, which operate within a sort of Spielraum. They're more like this or more like that. That's a political choice. That's believing in an institutional normative, believing in law as institutional normative order tells me nothing about that. In that sense, there's absolutely no reason why I couldn't be as firm an ethical positivist as Tom, except this marginal value judgment about how much interpretive reasoning is going to be going on, and how much we should encourage what we think of as good and enlightened interpretive reasoning, or, as it were, try to shut the door on it, put the hatch down and concentrate all on the legislative process. And you're right, we've got a good legislative process above all else. Yeah.
Okay, now there are just over 15 minutes, and there are still 5 people to go, so just be a bit...
So this time I won't, again, 5 and then Alan.
The cluster, Arthur being put at the top of the next one, Arthur, Gary and Margaret.
Very quickly, I wanted to take up what you just said then and what you mentioned in the middle of the paper. The idea that legal decision-making is always a concretization of a general norm in new circumstances, and the world's always trickier than the text. So that you're always going to have that inherent moment of whether you want to put law creation always at work in any sort of legal decision making, low level or not. I wanted to take that and then ask of the two bits that you brought together in the paper, just a question about each one. First, in the first bit of the paper where you talk about different levels of application, abstract, strict and discretionary, it seemed to me that there's enough in that insight from the hermeneutic position about how applying a general norm in new circumstances involves creativity and flexibility and things more than just reading off what the law means, to explain how people give it new meanings. So to put it a bit better, it's a matter of giving new meanings, not a matter of seeing the rule as defeasible. And particularly because you mentioned the rule has the same canonical form, but there are second order practical considerations that allow people to treat findings differently. That didn't seem to me what's at work now. And if you're proposing that for the future, why on earth would you want to conceal it like? Why would you want to put that in the canonical form? That you want to allow the decision maker to evaluate in different ways. With the second part of the paper, I'm not sure how to formulate this, but I was thinking, I thought the post-positivist institutional model was all about giving an account of law's autonomy, not in the sense of its self-directedness or like an agent, but in the sense of can you explain legal decision-making as generating criteria out of itself, which allows it to separate good and bad decision-making or legal decision-making. And then the strength of your account is it doesn't just look at the sources, it shows you all the methods, complicated as they are. And I was thinking, well, what more is involved in legal decision-making? And what would you say about this? How would you institutionalize it? And I thought of some, and I guess what you might say, the only one I could think of that linked back to that tradition of hermeneutics, which I think you would struggle with, is if you postulated the concrete norm and then the active decision later on as part of a tradition of thinking about a topic, then it's very hard to tame that, seems to me. It's very hard to tame it or to give it, put it into law, treat it as law having a separate criteria. If this case is about free speech, if this case is about how we treat people in a certain context, there's much more to it than what the legislature said about it and what other decisions even said about it. It's a larger topic, which you as the decision maker can't help but know something about, and if you're doing your job properly, should be drawing upon to make an appropriate decision. There's no way, it seems to me, to say that subject matter is legal, or obviously legal, or nor would you want it.
Neil, this is probably a question as much for Tom as it is for you. I wondered in reading your paper whether Tom could really be saying what you describe him as saying.
So did I, and then he said it.
You divide these rules, or the application of rules, into three categories: absolute application, strict application, and discretionary application. And then, at a later stage in the paper, you describe Tom's ideal legal system, his well-ordered legal system, as being composed entirely of the first category, inasmuch as statutory application or statutory interpretation were at stake. And in fact, that Tom would rein in all judicial interpretation by insisting on treating statutory rules as being rules of absolute application. That sounds to me like the end of interpretation altogether, as far as it relates to statutory application. In particular, in relation to something like capital televisions, where, of course, as in many cases, no matter how clear the statutory text is, there is always at least likely to be, or possibly, another text ready to enter the equation and complicate this act or non-active interpretation. And in this case, it was two views of the Constitution, or two views of implied rights. The sort of implied right to free speech as liberty, and the implied right to free speech as equality, and those two competed to a certain extent in this case. That's one question. The second question, it's actually more of a comment. I agree with you about statism and positivism, and I just wanted to use the example of international law again as a way of illustrating this. For at least a century, and probably longer, the statist conception of international law has been described effect, a customary system. So there's a further complication, I think, in the international legal order, which is that it's a positivist system, but it's also customary. I'm not sure how much that helps you with the various categorizations we're making at the beginning of the paper.
And Margaret.
Adverse to its task. Now, you acknowledge, Neil, that you rejected the strictness of tags being post-positive. I really wondered whether you were in fact a closet postmodernist, in fact challenged some of the foundational myths or beliefs of positivism, sovereignty, for example, the autonomy of law. You've accepted the plurality of law, the ambiguity of law, and recognized the importance of focusing on the particular, all of which seem to challenge in turn the things that you did want to retain, rule of law, and also the separation between a moral and legal order. And the latter you seem to be quite strongly in favour of. And I just wondered if you could perhaps elaborate a little bit on that, because it seems that those ideas are in fact corroded by those concepts that you in fact reject.
Do you want to write down the
Oh, okay. Why don't we do that?
it seems only fair to the
There are two people, John and Mark.
Neil suddenly started talking of, well, not suddenly, but that's flat unfair. Neil's been talking about question of degree, and I'm all for that. I think, however, there's two questions of degree and interpretation that I'd like to split out, because I think some of the discussion collided them. There's one question of degree when you look at a word's ordinary meaning as opposed to its contextual meaning. And this is because most words in English, and for that matter any other language, have, of course, are more or less in their application. A table is clearly a piece of furniture. A television stand is sort of a piece of furniture. A television might be a piece of furniture if you really push the word hard. So the way that we actually use words in English all the time, and everything our language is more or less. Now when we then use interpretation, of course, and have to interpret the text as a judge, you can't talk about words being more or less. They either have to be yes or no. Either it's a vehicle in the park or it's not. So the first question of degree is this play of the word's usual meaning, that a vehicle normally only includes, the sort of central core meaning of vehicle is car, as opposed to the contextual meaning. Well, in all of the sort of circumstances, we were prepared to think of a skateboard as in a park as being a vehicle. So that's one more or less question. And I would suggest that an activist judge is more prepared than a restrained judge to go further down that road of contextualising the text. And then there's a second, completely different question of degree, which is that given the outcome of that first process, nevertheless you just say, well, the outcome's silly and we're not going to apply the rules. And I think that's where you were invoking Fred's work on presumptive positivism and those sorts of things coming. And again, I think activist judges are more prepared to do the sort of recent harm type judgment than a restrained judge. But I think there's two different sets of degrees involved here, and I think it would be well to keep them apart.
Yeah, I'm not. This is a very inchoate question that may not be a question at all. It might just understand as a puzzle or confusion that I have. One of the things that's really fruitful about the way that this workshop is set up is that it explicitly draws together and makes us talk at the same time about political theory and legal theory. And the ethical positivism is the ethical positivism does in Tom's working out of it draws political theory. But you call it democratic positivism. I'm struck by the power of a noun over an adjective sometimes, not in that phrase, but say in the phrase liberal democracy. We're not just Democrats, but we're liberal Democrats. If we accept a certain orthodox populist democracy would predict in this room probably not get a large full of. If you switched it round and say we're democratic liberals, I wonder if you started to think of some of the arguments between Tom and Neil
sense, as I understand Tom, and I haven't worked through his book with this in mind, when he acknowledges that statutes aren't self-executing, his default position is to go back to the political theory, the democracy, and say, yeah, but you should hold them down as much as you can, these judges, because otherwise they're democratically unaccountable. But it might be different if you said, well, yeah, the democracy is an important component of it, but liberalism or liberty is an important component of it, and whereas rule of law, say, legality, is by process of empirical observation and argument, may be related to democracy, it is very closely related to liberty. And if that's your concern, as I think it is Neil's concern not only, you might say, well, one of the things that Montesquieu said about liberty is that the power shouldn't be too concentrated. There should be different people doing different things. And if they have to do different, it may be the judges who are a bit messy in democratic accountability terms, maybe still they have a bit of work to do, which even if it can't be accountability justified, might be, say, coherence. After all, legality is their process. And they've got to work on that. It's not something that legislators or even citizens are particularly finely attuned to. And anyway, they're in the road, and that's a good thing. And maybe if then I can't, and this is where the question just runs out of steam, if we could work in further notions from legal pluralism, so well, it's not just the judges, there are other things in the world which might complicate the democratic account, but actually be quite congenial to one which emphasizes the liberty, more liberal liberty, security,
I think that's very beautifully captured. Better than my answer. The point that Janet was also.
Yeah.
Yes. Since just we start there, I suppose that the worry is Tom has pointed out more than once that liberal liberty is all very well, but rich people it has much more value to rich people than to poor people. The Rawls thing. And if Philip Pettit were here, though he's not, he might want to say that there's Republican liberty as well, the liberty from domination. And what we do end up with is rather a lot of possibility of domination, not by Robert Badens nowadays, but by Mr. Murdoch and his like. So that, that there are other things that we have to worry about. But I think you're right, and I don't myself think that there's a sharp antithesis between Republican and liberal liberty, but when we care about freedom, we care about something that draws on both these traditions. Okay. Then to back to the top end, Arthur's points. I thought you were going to say, why didn't you just stop the paper at page 10? And I sort of wish I had. The answer why not? Well, Tom was paying a fare out of me. Come on, you can't just send 10 pages. Got to get something more into this. No, and also I think that it's true that that you want to think about rules and norms and all that kind of thing in a hermeneutic way, but then you also want to say, how does that play, that rather abstract analysis play into a more sort of thorough, gritty account of legal interpretation in real life? Now, I take your point, which is that they don't fit very well together at the moment, and that's got to be done better. And that is the sort of, that's the between now and the book sort of exercise. I'm very grateful for what you said, because I think it's all pretty well right. Also, autonomy out of places. The fact of the matter is that once you look at all the arguments one way and the other way, the act of weighing them and concluding them can no longer be can't just be, I think, accounted for as, well, that's the law. The judges say, well, that's the law. But that's the law because that's how it strikes us. As general practical reasoners, with all the foibles, etc. we have, I've got to decide this, here's how I decide it. And we all do the same in exams, deciding all the kinds of decisions we take. You come to the point at which, okay, the sort of existential moment of choice this has to be. And then you're back out the windowless monad. Right, Gary's point. Yes, just thanks. I think you sort of all together rather neatly. Well, just one remark, of course. It's interesting that the most anti-statist theorist of international law is Hans Kelsen, who's the only thoroughly consistent legal positivist there has ever been. Well, I'm not allowed to say that, am I, given my earlier thesis about the inexactness of positivism. But Etienne, who is a most distinguished and interesting in the descriptive way. Yes, am I really a postmodernist? I do sort of twitch. When I was a lad, things were modern if they were up to date. You can't be more modern than now. And I can't get my mind around post now. It kind of destroys a word. I mean, of course, there was the modernist movement in literature and architecture and painting and so on, and that did tie together with, I suppose, the jurisprudence of Llewellyn and Ross and Oliva Crona and so on. So that you could say there was, in that sense, a modernist school of thought in legal thinking at the same time as there was a modernist school of thought in these other things. But to me, it sort of jumbles up the history of ideas in a funny way to call some of what has gone on since then, or rather to say that modernism in legal thought was Bentham and Austin and that bunch, or Bentham and Austin and Thomas Aquinas and that bunch. I mean, modernism was much more like, well, I suppose there you have it. So what Kennedy and the CLS people and others are doing is taking on the insights of the jurists and others yet a step further. So that's fine. I guess I'm just wanting to say too much baby out with too much of the bathwater. There's much more left from those whom the modernists were criticizing, as well as from the modernists, than what I take to be postmodernism tends to say. But I agree with you that a lot of the stuff that I want to stand challenge a bit leaves some open questions, but I still want this line between morality and law. What I want is an acknowledgement of the difference between our position as ultimately responsible for how it is, autonomous agents, living in a society, not sort of moral geniuses or Nietzsche and heroes, but just people that have to get on with it. I do think that, but I want to do some more work, an awful lot more work. I do think that there's the very important idea